Good day and welcome to the NDI Checkpoint Web Conference Series. As a reminder, today's conference is being recorded. At this time, I would like to turn the conference over to Jennifer Bartz. Please go ahead.
Thank you, Robert. I would like to welcome everybody to the sixth session of our 2012 National Directors Institute Web Conference Series. We are in our 11th annual NDI season, a program which we started in 2002. As with NDI programs in past years, we are looking forward to sharing the insights and experiences on corporate governance issues that we think matter most to you. The goals and objectives of our NDI program have always been to provide practical insights and useful takeaways to directors, executives, and boardroom advisors. Materials for our previous NDI webinars and other sessions, including PowerPoint presentations and audio recordings, are available on our dedicated NDI website, which is foley.com/NDI. Information regarding future NDI webinar sessions will also be found on our NDI website. We held our in-person 2012 NDI Executive Exchange in Chicago on November 14th. Please go to our NDI website to find many valuable program materials from that all-day program. Our next invitation-only in-person NDI will be held Wednesday, November 13th, 2013, so be on the lookout for more information. I'd like to take this opportunity to thank all of our NDI co-sponsors, many of whom have been supportive to NDI for years, and some who are new to our program this year. Aon Corporation, C.F. King & Company Incorporated, Eversheds LLP, FTI Consulting, and KPMG, as well as our in-kind sponsors, Boardroom Bound, Inforum Board Access, and NASDAQ OMEX. Today, our program is entitled 2013 Proxy Season Preview. Our first speaker is Peter Fetzer. Peter is a partner in Foley's Milwaukee office. His practice focuses primarily in the areas of securities regulation, mergers and acquisitions, corporate governance, and general corporate counseling to mutual funds, exchange-traded funds, publicly traded investment advisors, and public companies. Following Peter is Josh Agan. Josh is an associate from our Milwaukee office. His practice focuses on assisting public and private companies in the areas of executive compensation, employee benefits, corporate transactions, and securities law compliance. Finally, we have Rick Grubaugh. Rick is the Senior Vice President at C.F. King & Company. He primarily advises corporations and shareholders involved in complex shareholder transactions, specializing in corporate control situations and proxy contests, mergers, and unsolicited tender offers. Rick also formulates and recommends shareholder communications for public companies in crisis situations. Before beginning our discussion, a few housekeeping items. Our conference call today will last approximately 1 hour. During this time, you may submit questions via the Q&A tab, which is located on your menu bar at the top of your screen. We will try to answer questions at the end of the program, but if we run out of time, we will follow up with you individually after the conference. We encourage you to maximize today's PowerPoint to full screen by hitting F5 on your keyboard, or from the toolbar menu, selecting View and clicking Full Screen. If you would like to print or save a copy of today's PowerPoint presentation, you can do so by selecting the printer icon at the bottom right-hand corner of the screen. Foley will apply for CLE credit for you after the conference. If you did not supply your CLE information when you registered, please email it to Jennifer Bartz at jbartz@foley.com. Note that you must log on to both the audio and the video to obtain CLE credit. Also, it can take 6 to 8 weeks for us to obtain all CLE approvals, so we really appreciate your patience in this process. And now I will turn the microphone over to Peter Fetzer of Foley & Lardner to go over a few more items and begin our program.
Thank you. We welcome everyone to the presentation today. I wanted to take just a few minutes at the beginning just to highlight the structure of the presentation. We're going to begin with an update on the status of the Dodd-Frank rules that impact proxy statements and proxy material for the upcoming 2013 proxy season, which is soon to be upon us. We will focus primarily on that in that section on compensation committees and compensation advisors and the new rules that have been adopted and proposed with respect to them. Following that, we will have a presentation on shareholder proposals, the primary focus there being on looking back at what went on in 2012 as an indication of what we might be expecting coming up in 2013. Following that, we will close with two presentations, one on voting policy updates from ISS, and then a presentation on Say on Pay. So at this point, we will turn now to our first topic, and I'll turn the time over to Josh Agan.
Thanks, Peter. So I'll just jump right in. As many of our listeners may recall, when Dodd-Frank was enacted in 2010, it included some new requirements for public company compensation committees relating to the independence of the committee members and their advisors. There were basically three requirements for, number one, heightened independence standards for compensation committee members. Number two, the authority of the compensation committees to retain compensation advisors. And third, a requirement to do an assessment of the independence of the committee's advisors. Now, tying this into the topic of this webcast, you might be wondering, how did these requirements affect our 2013 proxy statement? And I guess the short answer is that all of these requirements may affect disclosure about the committees and consultants in the 2013 proxy statement. I'll address that a little bit more later on. But first, I want to just do a quick status update just on where we are with respect to these rules. As you may remember, Dodd-Frank didn't directly impose these requirements. They were to be implemented through SEC rulemaking and through stock exchange listing standards. So in 2012, the SEC finalized its rules, and then the major stock exchanges proposed their listing standards earlier this year. There was a brief comment period, but only a handful of comments were received. The SEC announced just last week that it was delaying its final action whether to approve the proposed listing standards until January 13th of 2013. That will not, or is not likely to affect the ultimate timing. The final listing standards still must be adopted by July 27th of 2013, which, as you probably will note, is after most companies have their annual meetings. So now, just quickly to cover each of the three elements of these rules. The first, the independence of the compensation committee members. So under the New York Stock Exchange proposal, the boards would need to evaluate the independence of the committee members, considering all factors specifically relevant to determining whether the director has a relationship to the company that's material to the director's ability to be independent from management in fulfilling their duties as a compensation committee member. And then there are two specific categories that must be considered: the source of the compensation paid to the committee member, and whether the committee member is affiliated with the company or a subsidiary or an affiliate. So this determination has sort of these two extra required elements in addition to the regular evaluation for the independence of directors. The NASDAQ's proposed standards would be potentially a little more significant for NASDAQ companies. For one thing, NASDAQ would now actually require a compensation committee. Currently, it permits independent board members to satisfy the comp committee responsibilities. So NASDAQ would also require this committee to consist entirely of independent directors. And then they've got sort of categories under which the director would not qualify as independent for compensation committee purposes if they've received consulting, advisory, or other compensatory fees from the company or a subsidiary. And then the board must also consider whether the director is affiliated with the company in a way that would impair the director's judgment as a member of the committee. So to the question, does any of this affect 2013 proxy statements? On the one hand, the listing standards will not be effective until 2014. The New York Stock Exchange proposed timing, it includes a transition period that would last until the earlier of the first annual meeting after January 15th, 2014, or October 31st, 2014. NASDAQ's transition period would last until the earlier of the second annual meeting after the SEC approves the listing standards, or December 31st, 2014. So although these may not actually be mandatory until 2014. I think companies are in the process of evaluating their current comp committee members to see if they'll be able to meet these independence requirements. And so they're gathering this information, and I expect we'll see a number of companies disclose the independence of their committee members using standards, something like this, if they've already gathered the information and made the determination. So sort of voluntary, but it may we may see a number of companies do that. I think it's really just a question of how proactive companies want to be in terms of their disclosure.
And Josh, just one thing I would add in that regard, while you might not end up putting anything in the proxy statement, I think it's helpful to begin looking at the questionnaires that are being sent out and begin to ask some of the questions that might elicit the information you need. Because it's possible a number of companies will be potentially planning changes or adjustments to boards during the coming year in 2013, and it would be helpful to have this information.
Agreed. So the second of these requirements is relates to the responsibility of compensation committees. The SEC rules require listing standards that would give compensation committees the authority, the sole discretionary authority to retain or obtain the advice of a consultant or other advisor. The committee must be directly responsible for the appointment, compensation, and oversight of the work of any advisor that they do retain, and the committee must also receive appropriate funding from the company for the payment of reasonable compensation to the advisors. So we have proposed listing standards on these as well. They didn't really add much. The New York Stock Exchange currently requires a written charter for a compensation committee, and it's got various responsibilities that must be included in the charter. So it's going to, the New York Stock Exchange would amend those requirements to include the SEC requirements. And then NASDAQ would actually require a written charter. It currently does not, and that written charter would need to specify the SEC required rights and responsibilities for the committee. The New York Stock Exchange proposed effective date for this requirement would be July 1st, 2013. And NASDAQ is, I think, proposing that it be effective immediately when its listing standards are approved. So for NASDAQ companies, this could be a requirement early in 2013. The last category, the last of these three new requirements is the requirement for compensation committee advisor independence. And this is the requirement that I think is likely to have the biggest real-world impact of these three requirements, just because I think most companies will not need to change much to comply with the independence of the committee member requirement, because they probably already have independent directors on their comp committees, and the committee authority that's been considered a best practice for quite some time now. So many companies will be making small changes to their charters, if any. But the requirement to consider the independence of compensation committee advisors is more procedural, and I think most companies, if not all, are going to need to at least tweak their procedures for engaging compensation consultants to comply with these rules. So in a nutshell, the new rules require that before any compensation consultant, legal counsel, or other advisor to the committee the compensation committee is selected, the committee must consider certain factors related to the advisor's independence from management and the board. The 6 factors are the provision of other services to the issuer by the firm that employs the compensation advisor, the amount of fees received from the issuer by the firm that employs the advisor as a percentage of the total revenue of the firm that employs the advisor, the policies and procedures of the firm that employs the compensation advisor that are designed to prevent conflicts of interest. The 4th factor is any business or personal relationship of the compensation advisor with a member of the compensation committee, any stock owned by the compensation advisor or their immediate family members, and any business or personal relationship of the advisor or the firm employing the advisor with an executive officer of the issuer. The proposed New York Stock Exchange listing standards don't add any specific factors, but they have a catch-all that would require that the committee also consider all relevant factors. No additional detail on what those might be. And then NASDAQ, the proposed listing standards just they don't add any additional factors, and they don't have a catch-all. So the New York Stock Exchange standards are proposed to be effective July 1st of 2013, and the NASDAQ standards are proposed to be effective immediately upon approval. Again, for New York Stock Exchange listed companies, this may not be mandatory by the 2013 annual meeting, but NASDAQ companies may have to comply by then. And in any event, as we'll discuss in the next slide, there are reasons that you may need to evaluate the independence of your current advisors for purposes of the 2013 proxy statement.
And this is Peter. I would just add a couple things on the independence assessment that I think are yet to be resolved, and we'll have to see how they play out. The first is I want to make it clear that even though the board and the committee has to consider the independence of the compensation advisor, it doesn't mean that they have to be independent in order to engage them. There would be reasons that you would probably not want to do that, but it's not a prohibition. It just simply says that you have to have considered their independence. The other thing I wanted to point out is that they make it very clear that it doesn't matter who engages the compensation advisor. In other words, if it's the company that engages them, if they are providing advice to the compensation committee or considered an advisor to the compensation committee, you still have to make the determination on independence. And then the third thing that I think is going to play out, and it'll be interesting to see how it plays out, is just how do you determine someone who is not a compensation consultant but is either legal counsel or some other advisor, how do you make the determination as to whether they're providing advice to the compensation committee or they're an advisor to the compensation committee where this independence determination has to be made? And so we'll have to see how that plays out.
Yeah, I was just going to add, it's interesting that there's a distinction between the compensation consultants and the rest of the advisors in that the only disclosure requirement in the proxy statement is going to be for compensation consultants. So there's a sense in which there will be a lot less visibility by the public or shareholders into what the processes are for other advisors.
Yeah, because you're not required to disclose your independence assessment.
Right.
So that takes us to the next slide, which is, oh, sorry, Josh.
Yep.
Compensation consultant conflict of interest. This is one that clearly is applicable for the 2013 proxy season, and it applies to any compensation consultant that needs to be disclosed in the proxy statement. So any consultants you've been using for either executive officer compensation or director compensation that get disclosed in the proxy statement, you now have to run an analysis of whether they have conflicts of interest. And the intent of this disclosure is pretty straightforward. Basically, you need to disclose the nature of the conflict, if there is one, and how you address the conflict. And again, this will be applicable for the upcoming proxy season. What I have seen companies doing is talking with their compensation consultants, in some cases sending a letter requesting that they respond back indicating what they do to address potential conflicts and to confirm they don't have conflicts. Some have gone so far as to produce questionnaires that they send to their compensation consultants. My advice to this point has been to make this a cooperative process, to talk with the compensation consultants and work with them on the best way to address, first determining whether there are conflicts and then determining how you address them if there are any. I don't know if you have any other thoughts on that, Josh.
No, I think that's exactly right. I mean, the rule under 407E3 is just to disclose any conflicts of interest that have arisen. It doesn't say that you need to have any disclosure if you conclude that there are no conflicts. But I did see kind of an online poll suggesting that most companies or most people responding to that poll intended to include some disclosure in their proxy statement saying that no conflicts had been identified, just kind of affirmatively stating that so that there's just otherwise there would be no disclosure about this, and there's a possibility the SEC could ask, did you determine that there were no conflicts, or did you just miss this disclosure requirement if you don't say anything?
Okay, move on to clawbacks. Turn it over to you again, Josh.
Okay. This is another Dodd-Frank Act requirement that was going to be implemented through SEC rules and through stock exchange listing standards. And this would be that companies would need to develop and implement policies providing for essentially a clawback of any incentive-based compensation, and the clawback would be if there were a required accounting restatement due to material noncompliance with any financial reporting requirement, then the issuer would need to recover from both current and certain former executive officers the sort of the excess of the compensation that they received over what would have been paid if the financial reports had been in order the first time around. So there's not actually a whole lot to report here because the SEC hasn't published any rules, and it doesn't have a timetable anymore for publishing these rules. And so it's not much different from the analysis last year. As the slide notes, Sarbanes-Oxley already includes a clawback provision, but the Dodd-Frank clawback would be somewhat stricter than the Sarbanes-Oxley requirement. But I think for purposes of the 2013 proxy statement, a lot of companies have voluntarily adopted clawbacks as sort of a best practice, and obviously if they do that, I would recommend disclosing it in the proxy statement because it'll be perceived favorably by shareholders, at least those who pay attention to those sorts of things, that you have a clawback in place. Another Dodd-Frank requirement is for the SEC to issue rules requiring disclosure of pay ratios, and this would be the ratio of the median of the total compensation of all employees except the CEO, the ratio of that compared with the annual compensation of the CEO in the proxy statement. Again, not much to report here since last year because, again, the SEC hasn't published proposed rules on this, and there's no timetable for proposed rules. There was an AFL-CIO proposal to kind of try to help the SEC with this because I think part of the reason the SEC hasn't published rules is this is a very challenging rule to write and to make practical for companies to comply with, especially figuring out the median of all compensation. I mean, a lot of companies don't normally track that disclosure, so they'd have to develop sort of procedures for gathering it and vetting it, and also questions like, should it include non-U.S. employees and that sort of thing. So, but the Dodd-Frank language is pretty inflexible. So the AFL-CIO proposed that the SEC could permit the median of all employee compensation to be established through statistical sampling as maybe a practical solution that had reportedly gained favor with the SEC staff, but still no official word on this yet. A few companies voluntarily disclose their pay ratios. I think Whole Foods is an example where they think it helps them in some respect, but that's pretty infrequent as of today. Another Dodd-Frank requirement would be for disclosure of pay for performance in the proxy statement, and this would just be information showing the relationship between the amount of executive compensation and the company's financial performance. And it would likely include a graphic representation of the information. So this is something that, again, the SEC hasn't published any rules on, no timetable, but as you are probably aware, there has been a dramatic uptick in the number of companies including pay for performance disclosure in connection with Say on Pay last year and to some degree the year before, and I expect to see the same this year. So showing the relationship, a good relationship between the amount of pay your top executives are getting and the performance of the company is one of the most compelling arguments a company can make in favor of its say on pay vote. And there are many good examples out there of graphics that tell that story well. I think probably the most common type of disclosure is CEO pay or relative CEO pay shown against total shareholder return or relative to total shareholder return, with the relative measures being against the company's peer group. There are some other examples of other performance measures being used, but I think it's a good disclosure, especially if it can help to demonstrate what you're trying to accomplish with your pay programs, and it can really help with getting a favorable result in your say on pay vote. And I'll hand it back over to Peter for the other Dodd-Frank regulations.
And just two final ones here. We chose to include the one on hedging just simply to note two things. First, that companies are already required to disclose in their proxy statements policies they have in place regarding the hedging the economic risk of owning company securities. What the SEC has not done is to propose regulations that would require companies to disclose whether employees and directors are permitted to hedge the market value of securities that are granted to them as compensation. Again, there's no timetable on that, no indication as to when that might happen. The reason we include it on this slide is simply hedging continues to be something that institutional shareholders in particular are looking at. We'll get to this a little bit later on, but one of the ISS updates is a very clear statement that they are opposed, not opposed to hedging in the right circumstances. So just keep that out there. If you have adopted a hedging policy, probably a good idea to take a look at it and see if anything needs to be refreshed on it, but clearly companies cannot be taking action to adopt a policy that's SEC compliant because they've not proposed anything. The other thing on this slide is just a little unrelated, but might be useful if it ever is adopted, and that is that institutional investment managers will at some point be required to disclose how they voted on executive compensation. The final rules have not been adopted. There was a proposed rule, and that's something to watch just in the future going forward, because as they're required to make those reports, those will be potentially useful to companies to look at their shareholder base and see how their institutional shareholders are voting without the need of going through any kind of backdoor process or any kind of actual talking with these institutional managers. You'll have a source that will at least allow you to look back and see how they've looked at things in the past. With that, we will move on to shareholder proposals. I'll take the first few slides here. First, just a brief comment on proxy access. As most are aware, that was proposed, adopted, and then a lawsuit was filed. The rule was vacated. The end result of that was that shareholders do not have direct access to a company's proxy to put on a nominee. They are now free, however, to propose that companies adopt policies to allow shareholders to put nominees on a company's proxy statement. So what you saw last year in 2012 or this year were proposals to do just that. Many of them were allowed to go through, and Rick will talk about this in more detail on his slides. There were some that were excluded for things related to containing multiple proposals. They created conflicts with existing bylaw provisions. As I look through those, in my mind, all of those are things that are easy to cure and simple to cure. So my expectation is that in 2013, to the extent people are making proxy access proposals to companies, that most of the grounds for exclusion will have been rectified, and it will be much more difficult to keep a shareholder proposal off the ballot. The other thing I wanted to do before turning time over to Rick is just note that the SEC did publish updated guidance on shareholder proposals as companies receive those. I'll just touch on these briefly. They're a little bit technical. One item that shareholders have to deal with when they submit a proposal to a company is they have to verify that they actually own the shares. So the SEC has clarified if you have someone who's not a direct holder, which in today's world is most shareholders, that they need to obtain a verification letter to prove their ownership from a DTC participant or an affiliate of a DTC participant. If they don't do that, then they've not met that requirement. The second thing on this slide is this relates to deficiency letters. When you receive a shareholder proposal as a company, if it's deficient, you have to note in a letter back to the person submitting the proposal that it's deficient and give them a chance to cure. The staff noted that with regard to the one-year ownership requirement, they found that a lot of the deficiency letters that companies were sending didn't do enough to explain to the person submitting the proposal how they could, in essence, cure that failure to satisfy the one-year ownership requirement. So they now specify what the company has to put in its letter back to the proposer, saying what the deficiency is and how they can cure it. And the last set of things that were clarified relate to websites, because what a lot of people have done when they've made shareholder proposals is to try to include in the proposal reference to a website, where they then put in a lot more information that would not be allowed in the proposal itself. And what the SEC done has basically said that if you include a website, and the website is truly just supplemental, in other words, the proposal itself contains all the information that's necessary to understand the action that's being requested, the action that's being voted on, but it also references a website that provides some supplemental information, that there is the potential now that shareholders can do that and that it will be permitted. I expect that this is going to be closely watched because it will lend itself to potential of putting stuff out there that really shouldn't be in a shareholder proposal. And so to the extent anybody receives a proposal with a website, you would want to very carefully see what that website does or doesn't say in terms of responding to that proposal. With that said, I will now turn the time over to Rick to talk about the 2012 season.
Thanks, Peter. I'm going to spend a few minutes just talking about the top 10 shareholder proposals that we saw for 2012 and what we can expect to see for next year. This first slide shows the number of proposals submitted versus the number of shareholder proposals that go to a vote. And I use this to illustrate that depending on the proposal, many of the proposals are either negotiated off or the issuer capitulates and doesn't want to go to a vote knowing that the shareholder proposal will pass. And so in order to avoid the shareholder proposal passing, they just agree to put a management-sponsored proposal on the agenda, and the shareholder proponent would pull the proposal. So it's really important, depending on when you get your shareholder proposal, to immediately assess sort of how your shareholders have voted historically on this proposal so you can get a good understanding, and it helps you in the negotiating process. So now I'm going to go through each of the top shareholder proposals and kind of give you some highlights. First is the proposal to declassify the board. The overwhelming majority of S&P 500 companies have already destaggered. What we saw this year is Lucian Bebchuk, who is a Harvard professor. He created the Harvard Shareholder Rights Project and submitted numerous of these destaggered proposals to the S&P 500 companies. 44 of those companies agreed to bring a management proposal to declassify, and a bunch of others went to a vote. As we see, historically it gets a tremendous support for companies that are heavily institutionally held. So this is a proposal that most companies know if they get it, they are going to lose this proposal depending on their shareholder base. Okay, and we've already heard that Bebchuk has submitted 75 proposals for this coming year, 13. Okay, so by the time this is done, from the amount of companies that failed this proposal last year, which most likely will agree to put a management-sponsored proposal on the agenda this coming year, and the new ones that he's submitting, he's pretty much eliminated eliminated a classified board amongst the S&P 500, other than the handful of companies in that group that have high insider ownership. What Bebchuk has done is he's associated himself with a number of state and city pension funds. So he has the ownership interest in hundreds of companies, and then with his class. He's able to handle the legal minutia of going back and forth with no action letters. So he really has a bandwidth to submit, hundreds of proposals, and it's growing in great criticism, but he's still moving forward. This just shows the classified board based on the S&P 500 and Russell 3000. I would argue by the end of 2013, the number of classified boards will be under 10%, and whether or not he moves into the Russell 3000 is where, or he changes his proposals for next year. This year, the highest rated proposal we saw was the political contribution proposal, and obviously being an election year, that took center stage. What is interesting with this proposal is it hasn't gotten tremendous support among the largest institutional investors. However, this year we did see a number of the larger institutional investors either abstain on the proposal or request conference calls with the issuers to understand their policy and to see how the board has agreed to allow for political contributions, just to make sure that there is a active policy in place. And so it is not a topic that I think the institutions don't care about anymore. So I would watch this carefully as we go forward. And just because the election cycle is over, I would not anticipate this proposal to go away anytime soon. Shareholder proposal for majority voting likewise gets significant support, just like the de-stagger has gotten. Most of the S&P 500 has already adopted a majority voting standard or something similar. One thing of note this year is we saw a number of proposals submitted at companies outside of the S&P 500. Companies that have received high withhold votes or high negative votes on any proposal have seen majority voting proposals come in. So this is the one proposal that more companies are vulnerable to. What this graph just shows is that institutional investors are starting to accept the fact that if you have a director resignation policy, that does count. Okay, so some institutional investors are voting against a majority voting proposal if you have a robust resignation policy. So it is something to think about before you get a shareholder proposal on this. This just shows same graph as the before, where it just shows the number of S&P 500 companies that have adopted majority voting, those that have adopted it with a resignation policy, and those that are still in plurality. And you can see the S&P or the Russell 3000. More and more companies are adopting majority voting standard. It's one of the proposals that more companies are willing to adopt without allowing it to go to a vote. Next is a proposal for independent chairman. This obviously is the touchiest of the proposals when it comes to the importance. Institutional investors use this as a message. They vote case by case on this more than almost any other proposal, and if they want to send the message that they believe either performance-driven or changes needed, this will be a proposal that will be supported. However, it does not pass, and as you see, it only passed at 4 companies last year. And of course, some companies have adopted the standards of the lead director that will receive an ISS against vote on this proposal, which will help lower the voting records. But a lot of many companies, do not endorse all of the ISS issues, so they may adopt many, but not fully. Shareholder proposal report on sustainability. These social proposals are growing. They do get support, and more and more companies are adopting and disclosing much more. So if you look at a shareholder proposal that has created change although the proposal is not passing, many companies have, adopted on their website and post numerous types of disclosures. So they are working for what many of the proponents want, and then other proponents, and I'd throw that out. Some proponents actually don't want the companies to draft a policy and place it on their website. They just want their shareholder proposal to be out there in the public. Shareholder proposal to call special meeting. This is in conjunction with, also coupled with the written consent proposal. What the institutional investors have demanded now is that there needs to be a path to the boardroom outside of just the annual meeting process. And they're not overly focused on activism. They're more focused on if there's an unsolicited bidder launching an offer outside of the annual meeting window, that bidder has the ability to continue push the offer forward to ultimately get to have the shareholders vote on it via a director vote at a special meeting, and they're okay with that. That it'll take a while, and they don't think voting on allowing for a special meeting is in essence endorsing a proposal or an offer. They will make that decision at a later date. So even if companies adopt a high level of 25% of shareholders to call a special meeting, many of the institutional investors will endorse that in the event of a hostile bid to allow for, it's sort of like a free option to allow for the bid to go through. There's been much debate on what is the proper threshold. Early on, it started out at 25, and then many of the proponents had shareholder proposals trying to bring it down to 10%, and now it's more around the 15% is getting more investor support. But that said, in the event of a hostile bid, any bidder will get shareholders, will be able to get 15% to call a special meeting. Next is the shareholder proposal on the stock retention policy. This proposal did not get significant support because many of the proposals were too onerous. Many required that the executive officers not only held a large percentage of their equity compensation, but also held it 2 years post-retirement, and many of the institutional investors just believe that is too restrictive. And so one thing we're seeing this year is the proponents, they are educated as they go forward with their shareholder proposals, and many of the proposals this year are not going to include the 2-year holding period post-retirement. So I would not be surprised to see an uptick in this shareholder proposal support for next year. Proposals to eliminate supermajority provisions have always gotten significant support. And funny, this actually can work against a company. If a company's trying to get a shareholder, a merger passed, if there's a large shareholder against it, having a supermajority voting provision can ultimately block that. But this is right up there with the staggered board that if you have a heavily institutionalized ownership structure, your chances of defeating this proposal is relatively slim. Next is the proposal to act by written consent, and this is coupled with the special meeting proposal where what has happened is the institutional investors, and as you can see the sliding support, what has happened is the institutional investors have kind of come to the understanding that it doesn't matter what path you have towards the boardroom to support an unsolicited bid. It could be a special meeting or it could be written consent, but it needs to be one. So what you're seeing here is the reason the decline is these are companies that also either have the right to call a special meeting or have agreed to adopt the right for shareholders to call a special meeting. So more the institutional investors are voting against this proposal. I mean, it still gets substantial support, but it is not passing like it was just a couple of years ago. The final one we're talking about is the proxy access. This is obviously, we haven't seen that many shareholder proposals to get a good enough read on how this is going to be embraced by the institutional investor. And the reason for that is the shareholder proposals that we saw are across the map. Some had eligibility standards as low as 1% for 1 year. However, some had much more closely aligned to the SEC originally adopt proxy access, which was 3% for 3 years. And interestingly, both companies that had the SEC-style proxy access proposal, those two shareholder proposals passed. And the reason I say there's not enough data yet to say how this is going to play out, the two companies where it passed that were, let's say, in the corporate governance doghouse already. So it's not enough to read that if this proposal was submitted at numerous companies, how it would be endorsed. And what else? And this is just the final on all and the proponents that were submitting these. The one proposal that I want to spend a few seconds on talking about for next year, which is very interesting, is the Carpenters Union, Durkin, who was single-handedly behind the majority voting push, has submitted a number of shareholder proposals asking for companies to adopt triennial say-on-pay, which, as you recall, early on is all the institutional investors were pushing for annual. Many of the issuers were pushing for triennial, and Durkin was the only proponent out there pushing triennial. However, what this proposal is asking for is not just an up or down on a say-on-pay vote like it is under Dodd-Frank. He's looking for a three-pronged say-on-pay vote every 3 years, which would be both, which would vote on short-term, long-term, and golden parachute severance. So that alone, not too many issuers are inclined to embrace that up front, but it will provide some complexities for the issuers responding that had recently embraced a triennial say-on-pay and now will be forced to explain or rebut why they now want annual. So with that, I'll turn it back to you guys.
Okay, we'll move into the slides on the updates from ISS. I'll note a couple things here, and the way I view this is this is helpful, I think, just to understand sort of what are some key touch points or concerns for institutional shareholders. There were 3 things I'll note that changed in the update that ISS sent out on November 16th. The first is that clearly they've heightened the standards that they feel should be applied when a board and a company receive a shareholder proposal and that proposal gets a majority of the votes cast. In years past, what the ISS used to say is that if you got that vote with majority approval in 1 year, and then within the next 2 years you got majority vote approval again, that they expected the company to act on that proposal. And when ISS is talking about acting on it, they basically mean you either fully implement the proposal, or if the proposal was one that called for a shareholder vote before something was implemented, that the next time you have an annual meeting, you put it up for a vote. So the change here is to basically say 1 year is enough. So now if in 1 year you get a shareholder proposal and it gets a majority of the votes cast, the expectation on the part of ISS is that at the next annual meeting, you'll either implement that proposal or put it to a vote depending on how the proposal was worded. So that was the first change that we noted that was significant in what they provided. The second relates to hedging, and I misspoke earlier. What ISS has said with regard to hedging, and they also lump into this significant pledging, although pledging to some degree is allowed. But they view hedging of company stock as a severing of the alignment that directors and officers would otherwise have with shareholders. So in their view, if a company allows hedging, and in fact hedging is engaged in, and they say in any amount, they consider that a problematic practice that would warrant a negative voting recommendation on the election of directors. And then the third thing that we noted in their changes is just they've always been concerned about the ability of board members to sit on multiple boards and the concern that they somehow get overstretched and don't have enough time and resources to truly act as a fully informed board member. And so what they've done is they've indicated that if you sit on a board of a publicly traded subsidiary of another company, that will also count when they're looking at whether or not your directors are what they call overboarded. Then there were some compensation-related changes, and I'll turn the time over to Josh to run through those.
Thanks. First, I just want to do a quick public service announcement for people listening who are seeking New York CLE credit. They're required to email a 5-digit code to get credit. They have to email that to Jennifer Bartz and her email address is jbartz@foley.com. So the code that you need to email is MTELJ. So again, that code's needed only for those requesting CLE in New York. The code is MTELJ, and you need to send it to jbartz@foley.com, and jbartz is spelled JBARTZ. And with that, so the compensation-related updates from ISS, there were 3 that were worth mentioning. They're changing their peer group selection slightly so that they will now factor in, well, first they'll look at the 8-digit general industry code before they would consider 4 digits, and I think even 2 digits in some cases. In selecting the peer group against which they evaluate companies' pay practices to see if they are compensating excessively or not in ISS's view. And they're going to consider company-selected peers as an input into their peer group. So this is good news. ISS will now take a look at what the company thinks its peers are as well as what ISS thinks they are based on these GICS codes. They are adding realizable pay as a supplemental tool in their pay for performance analysis. So in addition to looking at kind of the grant date value of awards in evaluating the amount of pay, they'll also look at realizable pay as an extra concept, and that's only going to be for large cap companies, and it'll only be a factor if the company survives ISS's initial, doesn't survive ISS's initial quantitative analysis. That's part of the qualitative analysis. That's the second step in the ISS analysis. And then ISS will also now consider the legacy provision, and this is relating to the say on golden parachute vote recommendation from ISS. And this is, if there's a transaction, for example, like a merger between 2 public companies, there's an additional kind of say on pay vote, but it's just about the change of control compensation that executives receive. So now ISS, I guess in previous years, when ISS was deciding how to recommend how to vote on that compensation, they wouldn't look at sort of grandfathered provisions, change of control payments under old agreements, but now they're going to look at the whole package, including any existing agreements that might trigger a payout as a result of the change of control. And I'm going to, given the timing, skip right to the say on pay section of the presentation. So just a quick kind of rehash of the 2012 proxy season results on say on pay. They were very similar to 2011 in that the average levels were still around 90%. The average levels of shareholder support for compensation was around 90%. The vast majority of companies received majority shareholder support, and many, I guess slightly over 90% of companies in both 2012 and 11 received at least 70% of votes cast in favor of their pay. And 70% is significant because that's the threshold at which ISS thinks, if you don't get 70% or more approval in say on pay, they think you should be making changes as a result of those votes. There was a slight increase in the truly failed votes, those getting less than 50% or less than a majority of votes cast, but it's a very small percentage, something like 2.5% of companies in 2012. There was a correlation between failed say-on-pay votes and negative vote recommendations from proxy advisory services like ISS, so ISS continues to play a big role in, or at least appears to have some effect on say-on-pay outcomes. And so, the leading factors, again, were perceived disconnects between pay and performance. If you have a bad performance year, it's worth taking a close look at how your compensation levels are reacting to that. And then the presence of disfavored pay practices, which are pretty well known, things like single trigger payouts on a change of control, severance in excess of 3 times the base compensation of the executives, things like that. The say-on golden parachute votes that I was just talking about in the context of the updates from ISS, those are still relatively rare, but a couple of them have been defeated, but again, I think most of them have been successful. Consequences of a failed vote, as I mentioned, if you get less than 70%, ISS is going to look for you to make some changes. If you don't, they could end up recommending withhold votes from directors. And the one on this slide that I really wanted to highlight was the potential for litigation resulting from a failed say-on-pay vote, and that's the subject of this next slide. So the Dodd-Frank requirement for say-on-pay disclaimed that it was imposing any new fiduciary duties. Nevertheless, there were a series of lawsuits against companies by shareholders after a failed say-on-pay vote alleging things like wasted corporate assets, breach of fiduciary duty. Those have been largely unsuccessful, but there is a new type of litigation in 2012. A few companies have been sued by companies that, by shareholders that have alleged insufficient disclosure with respect to compensation, and they've actually brought suit before the annual meetings, tried to enjoin the annual meetings, and some of those have resulted in settlement payments. And I think that we are substantially out of time, so I'll hand it back over to Peter to wrap things up, I guess.
Yeah, I think we have hit our hour mark. We can go ahead and, if there were any questions that were submitted, we will make sure we respond to those and do that promptly. But otherwise, I think we can go ahead and wrap up the meeting. Jennifer, anything that needs to be read before we close?
Sure, thanks, Peter. I just want to thank all of our panelists today for their excellent insights regarding the 2013 proxy season preview. Contact information for our panelists is on this slide here, and we should have the slides and the information about the program up on our website within the next 24 to 48 hours. Please mark your calendar for the upcoming sessions in the 2013 NDI Checkpoint Web Conference Series, February 20th, May 15th, August 21st, and December 4th. And then also please save the date for our 2013 NDI Executive Exchange in Chicago on November 13th. And we hope you enjoyed today's presentation and ask that you please take 30 seconds to participate in a brief online survey at the conclusion of this call. The surveys are very helpful to us in ensuring that our NDI programs are providing you with practical advice and recommendations and help us to develop ideas for future NDI topics. Thank you again for attending our NDI, and we'll talk to you next on February 20th in 2013. Program details will be announced later this winter.
Thank you, and this does conclude today's conference call. Once again, we would like to thank everyone for your participation, and have a wonderful day.